A young defendant walked into court hoping for one thing: more freedom. But within minutes, the hearing took a dramatic turn. Prosecutors described allegations of domestic violence, resistance during arrest, and a police officer left seriously injured. As the judge reviewed the case, one question echoed through the courtroom: why is this defendant out on bond? That single question set the tone for everything that followed.
The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts is an R&O causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So hold on. There was a DV and then an officer injured. Why is he out?
Your Honor, if I could address.
Hold on. I'll let.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Hopkins. Mr. Hopkins, would you state your name for the record, please?
Mr. Hopkins. All right. What are we doing?
Your Honor, we would ask for a preliminary examination. We would also like to address bond, and there are no offers at this time.
Right. Is discovery complete?
It is my understanding, yes.
And would the people have their witnesses available on the 6th?
Yes, Your Honor.
Preliminary examination will be set in person February 6th, 2024, 9 a.m. That is before Judge Perry. As to bond.
Your Honor, we are just looking to address the condition of bond that requires that Mr. Hopkins be on house arrest. Prior to this matter, Mr. Hopkins was employed at FedEx. As a result of having the tether plate, no longer able to, in this case, he was no longer able to maintain that employment. He is wishing and hoping to be able to get new employment, and is asking that the court consider a no-go-to order, a no-contact order with the complainants, a no-go-to Eastern Michigan University, or anything of that nature. My client, Mr. Hopkins, also recently registered for the cybersecurity program at the University of Michigan. He did text me that information. I tried to send the confirmation to Ms. Barroso so that she would be able to see it. It's my understanding that the classes are majority online, but that would be the only place that he would have to come across Chenal County. Otherwise, he's just asking for some order that would allow him to work and just not have that kind of contact.
Response.
Your Honor, the bond in this case was set at $5,000 cash or surety when we requested a $50,000 bond. In this case, the people are uncomfortable with him being out. This was an event, or a series of events that occurred where the defendant assaulted the victim at not 1 but 2 locations. An eyewitness saw the defendant shove the victim while near the police station. The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts is an R&O causing injury.
The defense argued that the defendant was only 20 years old, had no criminal record, and simply wanted the chance to work and continue his education. But prosecutors painted a very different picture, describing a violent struggle with officers that allegedly ended with injuries, a deployed taser, and even a drawn firearm. The courtroom quickly became a battle between 2 completely different versions of the same incident.
That was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So hold on. There was a DV and then an officer injured. Why is he out?
Your Honor, if I could address.
Hold on. I'll let Ms. Barroso finish and then you can address it. I just had an intermediate question. Go ahead.
So at this point, I don't think that a modification of bond, removing him from being on house arrest is appropriate. We objected to a nominal bond of $5,000 when it was originally granted. At this point, I don't think that any further reduction is appropriate.
A couple of things. First of all, Mr. Hopkins is here with his father. He is 20 years old. He has no prior criminal history. In reviewing the police report and the video, even the report references that the altercation, that the incidents that resulted in this charge, that there were,
In which
that it was,
charge?
I'll start with the domestic violence. That with those charges, that there was a more complicated situation. I believe the officer said, the report says something to the effect of, and this would also go to the property, that there had been physical altercations between the two of them, fighting between the two of them, and breaking of objects between the two of them. So I believe that there's more to this than said. The allegations of the domestic violence are the one of the shoving, and also I believe Mr. Hopkins taking his own computer back from the complainant. That's the second allegation of the domestic violence. And the resisting and obstructing is, the allegations are that Mr. Hopkins, not that Mr. Hopkins turned around and slammed someone or punched them or anything, that he pulled away. The allegation is the officer fell and that caused the injury. And then that officer fell, yes, as he pulled away. And then subsequently, 4 officers who were, some of whom just pulled up on the scene in the video, all ran after him. And that's where the resisting and obstructing comes. And he did, in fact, eventually stop. It was not, it's not as if he were in a vehicle and went miles or hours away. He did stop running, and he did, once they complied, once that occurred, there were no further incidents.
Your Honor, I'm sorry, that is not the characterization of the RNO. The allegations include him punching 2 officers in the face, breaking free of their grasp, causing them to fall to the ground, twisting and seriously injuring an officer's finger. And then it went on for such a period of time that an officer had to point and deploy a taser.
Your Honor,
And that another officer had to point their pistol at a defendant. So at the defendant. So at this point, I don't think it was him passively.
Your Honor, I had an opportunity to view the video.
Well, you had an opportunity to view the video.
Yes.
Let me ask you this. Was a taser deployed?
Your Honor.
As the arguments continued, the judge carefully questioned both sides, trying to understand exactly what had happened. While acknowledging the defendant's clean record, the judge remained deeply concerned by the seriousness of the allegations. In the end, the court refused to relax the bond conditions, making it clear that public safety and accountability would remain the top priority until more evidence could be examined.
I think that's either yes or no. Was a taser deployed?
Your Honor, as soon as the officer saw him, she pointed the taser at him. This is not, as soon as she saw him, she pointed the taser at him. This is not a situation where he was running and pointed the taser.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video.
Ms. Burrows, are you indicating an officer had to draw their weapon?
That is what was indicated to me in the file, Your Honor. Yes.
And then there's an officer that's injured. Again, we'll ask the question. I don't know why this individual's out.
Again, Your Honor, he's 20 years old. He has no prior history, and he has no reason to come back to Washtenaw County other than for school in this case. It's my understanding, I have not heard any information that he has had any contact with the complainant, has violated any orders. He is just asking to be able to go to work and to be able to get a job and go to work. Your Honor, would you want to hear from Mr. Hopkins' father who's present?
I don't know what he could tell me at this point in time. I'm more worried about the bond as it originally is set. I don't, because what I have here and what's been indicated by the people is that he punched the officers in the face. Does he have prior convictions for anything?
No, Your Honor.
That the original domestic was about. I mean, I'm trying to figure out because I'll just tell you, I have some serious concerns that this escalated to a point that officers are having to deploy a taser, pull their weapon, and there are clearly enough officers around to, in my opinion, have subdued this individual without having to do all of that. So something else is going on. And
Your Honor,
I also have, I mean, one's bad enough, but I have 2 counts of domestic violence.
again, Your Honor, one of them is him taking back his own computer. That's one of the allegations. And that's why I'm saying there were things that were happening before this. That's not to excuse his behavior. That is to say that there's broader context. And in my view of the video, initially there was 1 officer, then there were 2, and he ran from 2, but as he's running from those 2, there are cars, 4 and 5 cars are pulling up with sirens on an unarmed young man who clearly panicked. This is not someone who's had police involvement, who has a history of contact with law enforcement and the criminal justice system. Again, I'm not excusing, but I do think that there's more. I think there are more nuances to this than the prosecutor does.
Well, explain some of those then. Because I've got a victim of a DV that's injured.
She is not, the domestic violence person is not injured. It was the shove and the taking of there's no injury to her.
Domestic violence are 2 misdemeanor counts.
That is
felonies
correct.
here are 5 counts of R, 5 counts.
Yeah, I see that.
Are no causing injury.
Maybe I misread that on the report, but
Yes.
the injury to the fingers, that's the officer.
That's correct.
Thank you. I don't understand this. I mean, there's a lot I don't understand. How, and I get there are resisting and obstructings that are filed that some may look at as questionable in terms of the charge. I get that. But I'm also trying to figure out how an officer gets injured, that there are punches to the face of officers. I mean, Ms. Gaines, I don't get it.
This hearing reminds us that bond hearings are not about deciding guilt or innocence. They're about balancing public safety with the rights of the accused while the legal process continues. Sometimes a judge's decision isn't about punishment, it's about caution. As more evidence emerges, the case will move forward. But today's hearing showed how every courtroom decision can have lasting consequences.
I understand what you're saying, and I'm saying I did not see any punches to the face when I observed the video.
Tell you what, I'm certainly not changing any conditions. Can you explain to me one reason why I shouldn't raise his bond?
Your Honor, he has appeared for every court date, and he has not picked up any new charges. He has not had any contact with the complainant on the domestic violence or any of the officers at Eastern Michigan University. My understanding from him is that he has only come to Washtenaw County for court. He does not even reside in this county. It does not appear he's a flight risk, nor that he is a danger to the community. He is here with his father. He has come to every court date, and he's highly responsive to my calls and texts. And absent the no offer in this matter, we'd be looking to resolve it.
Anything else from the people?
No, Your Honor.
You know what? I'm not changing his condition in the bond. I'm not at this juncture gonna up his bond either, although of rights I should. Of rights, I don't think he should be out around tethered or not, given that behavior. But I'll let Judge Perry deal with that after she hears the preliminary examination. Bond will continue. Motion for bond reduction or changing condition is denied.
Thank you.
Judge Simpson ultimately took a middle ground approach. He refused to loosen the bond restrictions, but he also declined the opportunity to increase the bond, despite openly questioning why the defendant had originally been released under these conditions. That decision reflects a key principle of pretrial proceedings. Bond isn't supposed to punish someone before they're convicted. It exists to balance community safety, the seriousness of the allegations, and the likelihood the defendant will return to court. The judge left the final evaluation for the preliminary examination, where the prosecution will have to present evidence establishing probable cause before the case moves forward. For now, the defendant remains on the same bond with the same restrictions, while the facts continue to be tested in court. What do you think Judge Simpson got right here? Should he have tightened the bond after hearing about the officer's injuries, or was maintaining the existing conditions the fairest decision until more evidence comes out? If you enjoy real courtroom hearings where every legal decision has consequences, be sure to like this video, share your perspective below, and subscribe for more in-depth courtroom breakdowns and legal analysis.